May you live in interesting times. So goes that sometimes ironic Chinese proverb. And interesting times is exactly what we have on today, May 23rd, 2023, where we have a Fifth Circuit Court of Appeals decision, sort of, that has issued an injunction blocking the pistol brace rule. I'm going to be going into the details on that. Yes, I know some of you have probably already seen this covered on other channels or outlets. I'm going to be taking this analysis well beyond that. And of course, if you did not already know, arguably the ATF has flip-flopped on their position about whether or not you can simply take off the stabilizing brace. I'll see if I can touch on that a little bit in this video. We'll see how we're doing on time. Otherwise, check it out in the description box below. My name's Tom Grieve, former state criminal prosecutor, criminal defense attorney, and guys, let's get into it. Have you heard sweeter words than this? It is further ordered that appellant's opposed motion for a preliminary injunction pending appeal is granted as to the plaintiffs in this case. So saith the Fifth Circuit Court of Appeals. That's the one headquartered out of Louisiana. And of course, the case we're talking about, one that we've covered multiple times on this channel before, is Mock v. Garland. Well, I had a chance to talk to a few attorneys who, by the way, are litigating this exact issue of the pistol braces. More on that in a moment. And basically, unfortunately, the prevailing consensus is that it only seems to apply to the plaintiffs in that case. So no, this does not apply to you living in the Fifth Circuit. This does not probably apply to the rest of us. This probably only applies to the particular litigants that are part of this case. So what's going on here, and why is this still important? Why are we doing a second video today to talk about this? Big things, that's why. So for starters, I want to remind you that we've interviewed the attorney Lucas Weber from the Wisconsin Institute for Law and Liberty, who is actually litigating another pistol brace case, Brito v. Garland, also coming out of the Northern District Court of Texas, and we await a decision when it comes to the preliminary injunction in that. This judge has done fantastic things who they drew in that case when it comes to Second Amendment issues in the past, as well as a number of other issues. We're going to have to see where he goes on this. Is he waiting for a last-second major bombshell decision until everybody else is cleared out of the room? He's the last one who can do something about it. For those of you who know this channel, you know that I'm going to be going up north. I'll be chainsawing next week, and whenever that happens, we seem to have great case outcomes. I did not schedule it that way; it just happened that way, but. Right. So I'll be gassing up the 261 and heading out into the woods. So possibly some really good things coming. Here's what I want to focus you on, though, when it comes to this video. And I briefly spoke to attorney Weber to get his kind of feedback on this to share with you. And he pointed out something that's absolutely fantastic and to be clear, I haven't watched every single outlet everywhere, but I haven't seen it covered so far, which is why this is tremendously good news. It's obviously not as good as it could be if it had just paused the entire rule, but why is it still tremendously good news? And it comes to the reason of what is the burden? What is the burden of proof that the plaintiffs, that's the good guys trying to fight the rule, that they had to accomplish in the court's view in order to get the injunction granted, ideally for everybody, but in this case, just for them. And it comes down to basically a four-way test. I won't bore you in all the details. Here's the relevant one. The very first thing the plaintiffs have to show in order to get a preliminary injunction, the plaintiff's likelihood for prevailing on the merits is strong. It's substantial. And they won on that here. This is obviously tremendously good news looking down the pipe as far as where are these cases going? Are they going to have a good outcome? We've seen fantastic case law coming up on Second Amendment issues this year alone, and as well as in the preceding 6 months. Coming out of the Fifth Circuit Court of Appeals, it has been a fantastically pro-Second Amendment court, and it looks like, at least the early signs are, I'm going to give them a 7.5 out of 10 because they did grant an injunction. They should have made it nationwide, or at least paused it for everybody in the Fifth Circuit. But hey, we'll take what we can here on May 23rd, a week before D-Day. So the fact that they've been able to show, and the fact that the court basically found that the plaintiff's likelihood of prevailing on the merits is substantial, that they paused it. Again, there's other prongs. If you want me to get into that, let me know. I can consider making a follow-up video. Let me know in the comment field below. But guys, this is really big. If you want to read the order, and believe me, I just read you the order. I do have a link for that in the description box below. Also, the description box is loaded up with all sorts of other goodies in there as well. I just want to briefly kind of cover, for those of you who may have missed the video before, can you take the stabilizing brace off? Because this has been a huge question. Questions continue to pour in my office today about this. Before I do that, please take a moment, if you've not already done so, show your support for the Second Amendment as well as this channel. Please consider clicking like, subscribe, share, make sure you don't miss any of our future content. Also, quick plug, we do exclusive extras, extra videos, extra content as well. It doesn't take anything away, but exclusive extras for membership. So please consider also supporting the channel if you could. Not the end of the world if you can't. End of plug. So here's kind of the real quick once-over on, did the ATF flip-flop back and forth? When the rule first dropped back on January 31st, they said that you have to destroy, or you have to permanently remove and dispose of or alter the stabilizing brace. Then on April 26th, ATF Director Dettelbach said, basically, no, you can just take it off and store it separately so you don't run into constructive possession issues. Again, deeper dive, check out the video linked in the description box below. And then yesterday, May 22nd, the ATF sent a video out to FFLs nationwide saying, oh, by the way, you know, in essence, we know that our director just testified under oath to Congress a couple weeks ago that, yeah, you can just take it off, but no. You've got to take it off and destroy it, throw it out, something like that. Right. So for the analysis on that, go ahead, check out that video linked in the description box below. The very long version is the safest thing you can do is from a legal perspective. If your value hierarchy is, I don't want to go to prison, then the safest thing you can do is to do the strictest form of compliance. I'm not by any stretch advocating for that. I'm just giving you information. Obviously, the other end of the equation is non-compliance, and then we get a bunch of steps in between, such as taking it off and basically doing what Director Dettelbach suggested, taking off the device, taking off the brace, and putting it separately so you don't trigger US v. Thompson Center issues. Again, more details, check out that video. So guys, hopefully you enjoyed that. I really look forward to continuing to stay up on this. If we get into next week, expect to see some lives being filmed from a cell phone up north. I really hope that we can have a video like that because it will hopefully mean good things. Thanks very much. Thanks for sticking around this long, and I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.